Smith was offering oats for sale and gave a sample of those oats to the defendant. The defendant took the sample of the oats, and at the next day, the defendant wrote to the claimant offering to buy 40 to 50 quarter of the oats at a price of 34 sterling per quarter. To begin with, 16 quarters of oats were sent to Hughes. By the time the oats arrived at his place, Hughes said that the oats were not as what he had thought and wanted. Hughes needed the old oat because the horses had it for their diet. The oats that were sent to him were green oats, which are the same type as the initial sample he got. The oats arrived are not as what Hughes thought, and he refused to pay Smith for the delivery and the remaining order. The court have decided that Hughes was liable to pay for the oats that he had given to Smith before, as he had carelessly mistaken the type of oats given by his own action. Due to his negligence, he could not blame his mistake and put it on Smith or illegally announce it as a mutual mistake. The principle of law that can be seen in this case is that in a commercial transaction where a buyer or client going to have their own expectation of what they want to buy, physically and how does it function. However, if suddenly the product turns out to be defect or his expectation towards the product turns out to be the opposite, he cannot apply for a refund or refuse to fulfill part of his obligation on the contract. In other words, Hughes cannot do anything or claim as it is due to his own negligence. Moreover, Smith is the one who are illegally responsible to inform Hughes of his afterwards mistake about the type of oats he already purchased. During the sale by sample was conducted between both of the parties, the court already strongly stated that there is caveat emptor principle in this case. Caveat emptor means buyer beware principle that stated the buyer should know everything about the product before conducting any official transaction. Thus, unilateral mistake was in principle no ground for the rescission of a contract, meaning he cannot cancel the contract easily. Both parties agree on the deals they have made, even after the sample oats are given to the buyer. During the agreement, they had no issue or counter offer at all. Even though both parties have their own terms and conditions, both parties did not explain their own terms and conditions in details. In other words, the contract was still present and both parties cannot easily apply for a rescission of contract. As stated in Act 1950, Section 12, Subsection 1, both parties should be in their right of mind and rational during the contract agreement are conducted. It's said to be rational for Hughes to send the younger type of the oats, as technically it is not right to offer and sell other types of oat that considered as defective product. To be concluded, there are no act of breach of contract, as Hughes never stated specifically type of oats that he wanted, and the contract is still legal between both parties. Finally, the case was dismissed while the contract was still valid. Jury stated defendant will not be liable if the word "all" is involved while entering the contract, as plaintiff will avoid it to enter the contract because he was selling the new oats, which is the green kind. Meanwhile, defendant was not specified the types of the oats he wants for his horses. This means even plaintiff is unknown about this fact. To be considered if that both parties are well known about their terms in entering the contract, as such the oats are old. However, in this case, defendant will not be held to be liable as the oats are new and not the old one. This means that the entering contract was a mislead by the plaintiff.